All right, you're ready to start.
Yes, ma'am. How you doing?
Good morning, how are you?
Good, good. We can start with position number 3, Mr. Babcock.
All right,
Good morning, Judge.
good
Sir,
morning.
I had sent you an email on this case saying if you would be willing to waive the BHET, position number 3.
All right, let me call that 26 CR 002176G. Let's see. Uh, Wait a minute, I'm getting something here with my camera. Hold on. Okay, now I have it. All right, state, you heard Mr. Haddad state that this is just to review, to go over the waiver with the BHET.
I'm sorry, was my confusion was, is this going to be a plea if we were to get rid of the BHET?
Yes, yes.
Okay.
Oh, okay.
Okay, yeah. And we're willing to do that. We just want to make sure he gets a social worker visit for housing if he hasn't had one already.
We'll have a social worker. Housing is not an issue, but we do have a social worker here as well.
Okay, we would just like them to meet with him. But with that being said, we're ready for the plea in this case.
All right.
I'm sorry, what position are we on?
2.
Okay,
Braxton Babcock.
Three is Babcock.
I'm sorry. 3. Braxton Babcock.
Yes.
And I think I called it Ms. Strong, 26 CR 002176G. All right, Mr. Babcock, I understand that you wish to take a plea today. Is that correct?
Right.
Okay, I have to be able to hear your responses. So, and the court reporter will need to hear you as well. So you might come a little closer. All right.
Correct.
All right. I want you to raise your right hand. I'm going to swear you in first. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Put your hand down. State, let me have the plea.
Yes, Your Honor. On the count 1 criminal trespass, states recommending 12 months, served 60 days, credit for time served, balance probated, social worker visit, stay away from all Clark Atlanta premises and property, and 60 hours community service. As for count 2, the willful obstruction, recommending 12 months probation concurrent with count 1, $300 fine. We would ask the defense stipulate the factual basis, venue, and ID for purposes of the plea.
Your Honor, we stipulate for purpose of the plea, ask the court to follow the negotiated plea, Judge.
All right. I will do that. Mr. Braxton, I'm going to ask you a series of questions to make sure that you understand your plea and that it is free and voluntary, okay?
Right.
First question is, are you presently under the influence of any medication, drugs, or alcohol, unprescribed medication, drugs, or alcohol that would impair your understanding?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Correct.
And that you're giving up and waiving the right to remain silent and not testify against yourself?
Correct.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Correct.
And that you are prepared and agree to waive these rights today. Is that correct?
Yes.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And you do understand that if you're on probation, it could be affected by your guilty plea today?
I'm sorry.
I said, do you understand that if you're on probation, it could be affected by your guilty plea today?
Yes.
All right. And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
So as to the charge of criminal trespass, how do you plead?
Guilty.
And as to the charge of willful obstruction, how do you plead?
Guilty.
All right, I will accept your guilty plea and you understand the conditions, correct?
Yes, correct.
Okay. All right. That will be it for your plea today.
I'm sorry, before we proceed, everything was the same except for the BHET, correct?
Correct.
Yeah.
And was there or was not a social worker visit?
She's right here. She's gonna talk to him right now.
Okay, thank you.
Good morning, Your Honor.
Good morning. How are you?
I'm good. It's good to see you.
You too.
I was sitting before you is position 21, Mr. Millsap.
All
Hi, Mr. Sirocco.
Hi, good morning.
Good morning.
How are you?
I'm good, and you, sir?
Doing good. We have we were asked for a 1 week reset for Mr. Millsap's case. We did send a felony transfer request for it, Judge.
Mm-hmm.
So we were asking for a 1 week reset to try and give the DAs time to respond on that.
All right. Who's the defense attorney?
It's a conflict case, Judge.
Oh, conflict. I saw Ms. McLeod on the schedule. Is she here yet?
She was on the phone a few minutes ago. She talked to a couple of people here at the jail. But she obviously knows about court.
Yeah. We may have to at least just come back to him. He had raised his hand, but he's still represented by conflict defender, so he may need to consult even though we're doing the reset. I don't want to do it without them here. So let's hold and come back around to him until they sign on.
All right, number 7, Mr. Clark will be next.
Okay.
Mr. Clark, the social workers.
Did you say 4th through 6th?
No,
On
no,
Chuck-
Position 7, Judge.
Sure. She's gonna talk to you.
7 is Willie Clark. All right, this is 26 CR 002328E, Willie Clark. State.
Yes, it's my understanding this is a negotiated plea. Is that correct, Mr. Wood?
It is.
Your Honor, for the count of willful obstruction, Judge, state's recommendation is 12 months, serve 40 days, credit for time served, balance probated, BHET, Op 21 law and decision-making course, a $300 fine, and 40 hours community service. We would ask that defense stipulate to factual basis, venue, and ID for purposes of the plea.
Mr. White, do you stipulate?
We do stipulate for the purposes of plea, Judge. We do have a few requests. We would ask to convert his $300 fine to additional 30 hours of community service and waive 2 months of his probation fees and allows to terminate or go non-reporting once he completes all of his requirements.
And we'd be fine with non-reporting, just not termination. He has, I believe, 5, I think, 3 active probation cases.
Okay. I will waive 1 month. And then he will go non-reporting after he's completed his conditions, and we will convert the $300 fine to 30 hours of community service for a total of 70 hours community service. Is that correct?
That's correct, Judge. Thank you.
Okay. Oh, there's Ms. McLeod. We'll get to you in 1 second, Ms. McLeod. All right, Mr. Clark,
Yes,
can you hear me?
yes, ma'am.
Okay, I understand that you wish to plead guilty. Is that correct?
Yes.
All right, raise your right hand. I'm going to swear you in first. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. And I'm going to ask you a series of questions to make sure that you understand your plea and that it is free and voluntary. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding?
Yes.
Sorry?
No, I'm not. And yes, I understand you. Yes.
Okay, I got you. Thank you. Are you satisfied with the services and representation of your attorney?
Yes, no, I have a few questions for the state, if you don't mind. If you guys
Nope,
don't,
this is not the time for questions. You should have
sorry.
asked your attorney that.
I'm sorry. Yes, I'm satisfied.
Okay. And are you ready to go forward with your plea today?
Yes,
And are you clear on the terms and conditions?
yes,
All right. And do you understand that by pleading guilty today, you're giving up or waiving the right to the presumption of innocence?
yes,
And that you're giving up and waiving the right to remain silent and not testify against yourself?
yes,
And that you're giving up and waiving the right to remain, and giving up and waiving the right to trial by judge or jury, whichever you prefer.
yes,
And you are prepared and agreed to waive these rights today.
yes.
Has anyone told you to receive a lesser sentence for pleading guilty?
No,
Has anyone promised you anything to plead guilty?
no,
And you do understand that if you are currently on probation, it could be affected by your guilty plea today.
yes,
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
yes.
All right, as to the charge of willful obstruction, how do you plead?
Guilty.
All right, I will accept your guilty plea and you understand your conditions. All
Yeah.
right.
Mr.
All right.
Haddad, he would like to speak to the social worker about housing.
Yeah, we talked about that. Yeah.
Okay, great.
Thanks, Mr. White.
This was waived 1 month, and was it non-reporting or no?
Waive 1 month and then go non-reporting, yes.
Thank you. I'm sorry, yeah.
All right, we go back to the conflict case down at ACDC with Attorney McLeod.
That's number. That's number 7.
Where should I be able to do? Watkins. I'm doing number 38, Mr. Watkins.
Okay, are we able to real quickly take Mr. Millsap so we can just do the reset on that? Position 21 real quick.
Good morning, Your Honor.
Good morning, how are you?
I'm fine. I was speaking with one of my clients.
Oh, I know you're doing about a million things, I understand. All right, this is Mr. Millsap, case number 26 CR 002206B, Mark Keith Millsap, charged with 1 count of loitering and prowling. I think the state has an announcement on that.
Yes, it is that we are requesting a 1-week reset. For the felony transfer request that's currently pending.
Your Honor, we would object to this because he is sitting on a good bond in jail, a $5,000 good bond that he cannot pay. Would the state consent to a signature bond for him?
We would not, Ms. McLeod.
Well, is there any particular reason why he doesn't qualify for a signature bond, Mr. Shirako?
Let me pull it up.
And I'm not privy to his record at all, so I'm asking.
I understand.
This is 21, correct?
Correct, Mr. Millsap.
Thank you. Yes, Ms. McLeod. He does have recent conviction, Tennessee, domestic assault, pled just this February, actually. Also other arrests out of Tennessee for unlawful possession of a weapon, assault. I know one of those was dismissed. The issue here is this was the essentially he's a party to entering auto, Your Honor. And it was a group of individuals, Mr. Millsap included, as well as Mr. is also on this calendar, Lackey, position 18. And they were essentially going to the 925 Canterbury Road location in Atlanta. There were several males pulling on door vehicles. And one of them, his case is currently in Superior Court for, it's under, I don't have the PI number in front of me, for possession of a weapon during commission, entering auto, loiter prowl as well. His name is, I believe, Anthony. Just sent this yesterday as well. Yes, his name is Anthony Hambrick, 26 PI 002684. One of these defendants was acting as a lookout. They were all working in concert with one another. And then it was Mr. Hambrick who essentially pulled out a firearm and approached the victim, Miss Vardit Brown, who saw all these individuals, later identified them, going around various vehicles at this lot and trying to break into them. She identified the defendant as well as the suspect vehicle, of which they were all later located in by law enforcement in that vehicle. Multiple ski masks, several pairs of gloves, flashlights, backpack with 9 blank key fobs and an Autel key fob programmer for use in gaining access to vehicles. So this was a whole operation here, Judge. It's a public safety case, and we're requesting a felony transfer for it. That's why this bond was set at $5,000 surety. Let's see, and the name on that, the judge who signed that order was Judge Lal on April 4th, 2026. There's been no change in circumstances since that. We would request that bond remain as set.
All right. Attorney McLeod.
Yes, Your Honor. He's not in a position to pay for bond, and he doesn't have anyone on the outside to fund the bond for him. That is why we were asking for at least a consideration of a lower bond for him, because he cannot pay that $5,000 bond.
Right. And his present bond is what, Mr. Shiraka?
That's a $5,000 surety bond, Judge.
All right. I will stay with that $5,000 surety given his history. And so I will grant the state's 1 week reset. And then we'll go from there in 1 week.
Thank you, Your Honor.
All right, thank you.
And if we got 2038, Mr. Watkins.
Okay.
Well, I know that I have
All right, this is 26 CR 002177J. And Quiris Watkins charged with 2 counts of simple battery, family violence, disorderly conduct, and criminal trespass. State?
I don't have an announcement on this. What is this, Ms. McLeod?
Your Honor, I've already waived arraignment on behalf of Mr. Watkins. We would like to address the issue of his bond to see if we could get his bond reduced or whether or not he could have a signature bond.
All right. What's the present bond?
Appears to be a $6,000 total surety, $2,000 on the simple battery family violence charges each, and $1,000 on the disorderly conduct and criminal trespass charges respectively.
And his history.
I can provide if pre-trials, we have pre-trial on? Yeah, we
Pre-trial
do,
here?
right?
Okay. Pre-trial?
She was on, she must have gotten off. She's not on anymore.
Okay,
Okay.
that's no problem. Your Honor, there is a NOLO for disorderly conduct. It's 19 SC 165320. It's a disorderly conduct that was ultimately pled down from an aggravated assault family violence against the same victim as in this case, Miss Aisha Wells. That was for strangling her. He was sentenced to 12 months to serve. Prior simple battery conviction 2005, prior forgery in the second, and possession of cocaine with intent to distribute 2008. There are older arrests for reckless conduct and terroristic threats and acts, felony. I don't have dispositions for those, but there are a number of FTAs, 2020, 2011, 2005, two from 2001, 1997. So 6 FTAs that I found most recently in 2020. And additionally, he has an open case. It's an aggravated assault, family violence, strangulation, as well as 5 counts of cruelty to children in the third. And that is also against the same victim, Aisha Wells, for strangling her with his forearms in the presence of 5 minor children. The incident here, and that's under 21 SC 179358. The incident here, April 1st, 2026, took place at 320 Fairburn Road. It was apartment D1, Atlanta. Officer was notified by an extra job unit that there was a domestic dispute occurring at the location. Upon arrival, officers made contact with Miss Aisha Wells, again, the victim, who had flagged the other officer down and explained that the defendant, who is her ex-boyfriend, they'd been dating for over 10 years, living together, had just slapped her in the face. Officer spoke with Miss Wells, got her statement. She was sitting on her chair in the living room, she stated. Defendant was upset because her friend, her new girlfriend, Miss Ashanti, was home. Defendant walked by Miss Wells, slapped her in the face with an open hand, and sitting directly across from Miss Wells was her daughter, I believe juvenile MW. The defendant then kicked everyone out of the home, locked them out. And it was then that the daughter had to climb through a window and actually open up the door to let Miss Wells back in. The defendant, after this, had armed himself with a kitchen knife and began walking around with it. The officer was able to observe the defendant with the knife on the video that the daughter had recorded. He is seen holding the knife, and then at that point, more contact with her, pushing her to the ground there, causing her to fall. The defendant was ultimately arrested, with this being his third case against the same victim, with him being in violation of his $15,000 straight bonds conditions under that open case. Excuse me. With no further contact, stay away provisions there. And that is again 21 SC 179358. And with the other two cases, one confirmed to have involved strangulation conduct, and the other one alleged strangulation, we have an enormous concern for the victim's safety here. There's also a substantial risk of failing to appear. And that is based on his prior FTAs. I believe, yes, Judge, and that is why the $6,000 total good bond was set here in this case, and we would ask that it remain set. There's been no change in circumstances since the bond was set on April 3rd by Judge Lal. And again, that includes no further contact with Miss Aisha Wells and her children. Stay away from the apartment complex, that entire complex, which he should have been staying away from anyways, and didn't here. So that's why we'd request it would remain as set, Judge.
All right. McLeod?
Yes, Your Honor. My understanding is that he has been in jail for quite some time. So obviously he can't pay for this bond, Your Honor. And of course, it is always better for someone to be able to fight charges like this if they are not sitting in jail. The state's plea offer would require him to spend, I think, approximately 4 or 5 months in jail. And we do not think that is a reasonable offer, Your Honor. So that was why I was asking for some kind of reduction in this bond to at least increase the possibility or the likelihood of him being able to bond out and to fight these charges while he's on the outside.
No, actually, that seems like a reasonable bond based on the fact that this is a repeated case with the same victim. Normally, when I have those, it's a cash bond, but I will not lower his bond, that's for sure. So it'll stay as it is for now.
Thank you, Your Honor.
All right, thank you. All right, who do we have next?
Your Honor, for my other client, Mr. Glenn, this is going to be a waiver of arraignment, which I've already waived his arraignment. And we would ask that this case be set for the next available trial calendar.
And which Glenn is it, Ms. McLeod? There's two. Is it Terry or Xavier?
Oh, Xavier.
Okay, thank you.
Yes.
All right, that's position 15, the waiver, okay?
Yes, Your Honor.
And do you
And
have
that
any
concludes
others?
my,
Okay,
not on this calendar, Your Honor. I have on the 11 o'clock.
okay. All right, thank you. Your excuse.
You're welcome, Your Honor, and I will log back in for that calendar.
Okay, thank you.
All right, next we have number 8, Mr. Colton.
Huh?
No, there's
That position 8, Cotton?
Yes, ma'am.
Okay. 26 CR 002179K. Dennis, I'm sorry, Colton, COLTON. I mispronounced. Okay. State.
And
Go ahead.
this will be a negotiated plea.
Okay. State.
Yes, Your Honor. The state's recommendation for position 8 on count 1, it reads a little bit differently on the calendar, but count 1 is actually the simple battery family violence. On that, we are recommending 12 months served 28 days, credit for time served, balance probated, recommending an 8-week anger management, ADET, MHET, and no further violent contact with Debbie Peppers. We were requesting a stay away from 501 Carlton Road, Palmetto. It's an apartment complex. We are, I believe, make sure. Yeah, we can, we're going to take that stay away off. We did speak with the victim. I'll finish the recommendation. Count 2, simple assault, family violence, 12 months probation concurrent with count 1, no further violent contact with Debbie Peppers. And for count 3, willful obstruction, 12 months probation concurrent with count 1, $300 fine. We did speak with the victim. She does agree with the recommendations. She believes that all this will be good for the defendant. And she requested the stay away be removed. She was reluctant at C, which is why we recommended the stay away initially. She wanted no further violent contact at C, and what a possible stay away, she couldn't decide there, so we wanted to err on the side of caution. But she's since requested the stay away be removed. She does take care of the defendant, who has MH and certain diagnoses that she helps care for. And let's see, she wants certainly the ADET, MHET, and she says the defendant's been taking street drugs instead of prescribed medication for his diagnoses. And he hasn't seen his psychiatrist or anything since he was 18. And has trouble maintaining employment. So we think all of this will be good for him here. We would ask the defense stipulate the factual basis, venue, and ID for purposes of the plea. And if we could just sound for Miss Debbie Peppers in accordance with Marcy's law.
All right, it's Debbie Peppers. Don't think she's on. All right, go ahead, Mr. White.
Your Honor, we just ask you to accept the plea as negotiated. We would ask to convert the $300 fine to 30 hours of community service, as he has no employment, waive at least 2 months of the fees, and allow him to go non-reporting upon completion.
We would object to non-reporting, given that he's had some issues with taking medication and adhering to other requirements as part of his condition. With respect to checking up on him, follow-ups, I don't think reporting is a bad idea for him.
They just have to come in and give him $50 and then tell him to turn around. It's not like they counsel him or anything of that regard. So, I mean, and there's no order in the plea agreement that requires him to take medication or anything of that nature. So, I mean, it seems ridiculous to have him just go to probation, hand him $50, and thank you, we'll see you next month.
Well, we would object regardless. We have it's a family violence case here, Judge, and that's the state's position. Also appears to be an open terroristic threats and acts and reckless conduct out of Coweta.
I will accept, we'll change the $300 fine to 30 hours of community service. I'll waive 2 months of his probation fees, and he will have to stay on probation the full time. Are you willing to accept that, Mr. White?
Yes, we have accepted that, Judge.
Okay. All right. Mr. Colton?
Yes.
I understand that you wish to plead guilty today. Is that correct?
Yes.
All right. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. You can put your hand down. I'm going to ask you a series of questions to make sure that you understand your plea. All right. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding at this time?
No, I'm not.
All right. Are you satisfied with the services and representation of your attorney?
Yeah.
Are you satisfied? I'm sorry, do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Right.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Right.
And you are prepared and agree to waive these rights today, is that correct?
Right.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
Right.
Has anyone promised you anything to plead guilty?
Right.
And do you understand that if you're currently on probation, it could be affected by a guilty plea today?
Right.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
All right. And again, as to the charge of simple battery, family violence, 2 counts, how do you plead?
Guilty.
And as to the charge of willful obstruction, how do you plead?
Guilty.
Y'all know where felony probation
I didn't hear you.
Guilty.
Okay. All right. I'll accept your guilty plea. And you understand your conditions. Is that correct? All right. Thank you.
Still in the front row. In the first row. Here's one of the deputies. Oh, let me grab him. Let me grab Pleading number 10, Mr. Denzar.
Yeah.
Private attorney case, Mike Moran, and I don't see him on.
Ms. Strong, you see Attorney Moran on, or has he been on?
No, ma'am. We'll reach out, Judge. Can we come back to him?
Okay.
Your
We'll have
Honor,
to reach
I'm
out to his attorney. Yes, ma'am.
can we go to position 25 and 26, Miss Alexis Sims?
It's gonna be a negotiation. Yes, she's on.
All right, this is case number 25 CR 006759K, Alexis Sims, charged with 1 count of criminal trespass. And position 26 is 26 CR 000295K, Alexis Renee Sims, with 3 charges: simple assault, willful obstruction, and criminal trespass. State?
Yes, I'm sorry, Mr. Bartels, what was the announcement on this one?
Yeah, good morning, Your Honor. Good morning, Mr. Shiraka.
Good morning.
Good morning.
We are going to be entering a plea to both cases, Judge. We do have the recommendations from the state. We are in agreement with the terms of the sentencing, except for community service on 2 of the charges. She's got a number of other conditions that she would have to fulfill, Your Honor. And given the amount of time that she's been in jail, I think those other conditions would be more than sufficient. She's been in jail for 94 days on number 26. And looks like she served 102 days on number 25, which is a trespass. So we're in agreement with the state's recommendation, except for the community service on both cases.
Does she have stable housing, Mr. Bartels?
No, we've expended, we spent a lot of time and effort trying to find a placement. There were a couple of, or several places that were not able to take her. And the reason is that under the new regime, when somebody on disability is in jail for more than a month or so, their benefits get cut off and they have to start again applying when they can. So at this point, we have not been able to locate a placement. And her case has been reset. We'll have to do that, but she is ready.
Okay. Yeah, that's fine. You know what? We'd be fine with removing the community service. She has spent some significant time in jail here on both cases, it appears. We can proceed with a negotiated plea then.
Okay.
For position 25, Judge, the
Mhm.
criminal trespass, state's recommending 12 months probation concurrent with the other open case, position 26. Stay away from Emory University Hospital, Midtown. It's at 550 Peachtree Street in Atlanta, absent a bona fide medical emergency. And as I said, we'll remove those community service hours. For position 26, it's the simple assault, obstruction, and criminal trespass, counts 1 through 3 respectively. For count 1, 12 months served, 94 days, credit for time served, balance probated. MHET, 8-week anger management course. No further violent contact with Grady Hospital security and staff, to include Miss Candace Nunez. Stay away from Grady Hospital, that is at 88 Jesse Hill Jr. Drive in Atlanta, absent a real bona fide medical emergency. Count 2, the obstruction, 12 months probation concurrent with count 1, $300 fine. And the criminal trespass, 12 months probation concurrent with count 1. Stay away from, again, Emory University Hospital, Midtown, absent bona fide medical emergency. And as I stated, we'll be removing the community service as to that. We did speak with Ms. Nunez. She agreed to the state's recommendations, although that did include the community service, but it's unclear how consequential that was to her. I believe it's likely the stayaways and no further contacts that should be in accord with here. If we could sound for her when appropriate, we would also ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
We would so stipulate, Judge, and we would just ask the court to accept the plea agreement as outlined.
All right, I will accept the plea as outlined. Ms. Nunez, she on the Zoom? All right, we'll go forward. I understand, Ms. Sims, you wish to plead guilty to both cases?
Yes, ma'am.
All right, raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down for me. I'm going to ask you a series of questions to make sure that you understand your plea, okay?
Mm-hmm.
All right, first question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding at this time?
No, ma'am.
And are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
Okay, and that by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself? You understand that?
Mhm.
I didn't hear you.
Yes, ma'am.
Okay, and you understand that by pleading guilty, that you're giving up the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today, correct?
Yes, ma'am.
All right. Has anyone told you that you'll receive a lesser sentence for pleading guilty?
Nobody told me that.
Okay. And has anyone promised you anything to plead guilty?
No, ma'am.
Okay. And do you understand that if you're currently on probation, it could be affected by this guilty plea today?
Yes.
Okay. And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
All right. As to the charge of criminal trespass, how do you plead?
Guilty.
As to the charge of simple assault, how do you plead?
Guilty.
As to the charge of obstruction, how do you plead?
Guilty.
And as to the charge of criminal trespass, how do you plead?
Guilty.
Okay. All right. I accept your guilty plea to both cases and all charges, and you understand your terms and conditions, correct?
Mm-hmm.
Okay. All right. Thank you so much.
And Your Honor, especially given the fact that he's not getting your disability now, we would ask the court to consider waiving the first month's probation fees.
All right, I'll waive the first month of probation fees.
All right, thank you, Judge.
Uh-huh.
And just to confirm, she is still paying the fine, right? Okay. thank
Thought
you.
so.
Okay, I just wanted to confirm. Thank you.
Okay, just no community service.
All right, thank you.
All right, that's got 27, Mr. Smith.
Thank you.
Uh-huh. This is 26 CR 002189A, John Smith. State.
Yes, Judge. We did request a 1 week reset for this case for a felony transfer request here. So that is the state's position here.
Is his attorney here? It says private attorney.
It's Renee Rockwell. She is on the Zoom.
All right, Attorney Rockwell. Attorney Rockwell. Do you see her on, Ms. Strong? She's still signed in. She may be in multiple courts.
She is still signed in, Judge. I'm sending her the notifications. Maybe she's not. Oh, there she is.
There she comes. Okay.
Hey there.
Good morning. How are you?
I'm good. I'm sorry, Judge. I'm in Carroll County.
I figured you were somewhere in multiple courtrooms.
Yes, thank you for holding. Thank you so much. I have John Smith,
Right.
and I don't think we're going to be able to do anything today.
Right.
His most important problem, Judge, is he's got a felony probation warrant, and I don't want to do anything to complicate it.
The state has asked for a 1 week reset.
Oh, okay. Can we appear on Zoom next week?
Yes.
No objection. And who's my prosecutor?
That's me, Ms. Rockwell. How are you?
Okay. Good. No objection. He's so
Okay.
reasonable, I could never tell him no.
All right.
Thank
Sounds
you.
good. All right. We'll see you next
All
week.
righty. May I
Thank
be
you.
excused?
All right. Yes, you may.
All right.
Thank you.
All right. Thank you, Judge. Thank you, Mr. Prosecutor.
All right, 31 on Townsend.
Huh? This is 26 CR 002192E, Anthony Townsend. State. And you have private counsel, I see here, or no?
No, we're not. Timothy Mergler for the defense.
Tell me your
And
name. Tell me your name again, sir. I'm sorry.
Timothy Mergler, Mergler, and I go by TJ.
All right. We will not call you TJ, but we will say Attorney Merkler. All right. And I see Mr. Moran. Hold for a second, Mr. Moran. We'll get to you next. All right. Thank you. All right. Go ahead, State.
I am uncertain. Is this going to be a plea or not? Or is this a non-negotiated plea, Mr. Mergler?
I believe we are going to proceed with the negotiated plea.
All right. Your Honor, on the count of criminal trespass, the state's recommendation is 12 months served, 90 days, credit for time served, balance probated, BHET. Stay away from the Walmart that is at 840 Cleveland Avenue. 844 Cleveland Avenue. That's a typo there. In East Point, and 40 hours community service. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
You stipulate.
Excuse me. And Mr. Murder, and I'm sorry if I've mispronounced your name. Is that your understanding of the plea terms with the state?
Yes, we were going to ask for a waiver of fees if possible, and also to go to non-reporting status, given that after he completes his community service and his BHUT, just given the amount of times.
That's fine, for non-reporting following completion of the conditions.
All right, I cannot waive all of the fees. I will waive 2 months of his probation fees. And then he can go non-reporting after he's completed all of his conditions. All right. And so, Mr. Townsend, are you ready to take your plea? All right, raise your right hand for me. I'm going to swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? All right, I'm going to ask you a series of questions and make sure you understand your plea today, okay? Are you presently under the influence of any unprescribed medication, drugs, or alcohol at this time that would hinder your understanding? And are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agreed to waive these rights today, correct?
Ma'am.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation could be affected by the guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
So as to the charge of criminal trespass, how do you plead?
Guilty.
All right, I will accept your plea and you understand the terms and conditions, correct?
Yes, ma'am.
All right, that will conclude this matter.
All right, go back number 10, Mr. Denizar.
Okay.
Is Mr. Moran his counsel?
Yes, I am on here. And Your Honor, I apologize. I'm not in coat and tie this morning. We didn't get notice of this until just a couple of minutes ago. So I hope the court will indulge my informal attire.
I will. I told Ms. Strong, give him a call just to make sure, because I know it's not usually like you not to show up. So we will excuse that. Thank you for being able to get on Zoom.
Thank you, Your Honor.
All right. This is case number 26 CR 000-451A, Michael Denizard, I believe. State, what do you have?
I would inquire as to what the announcement will be. State did make an offer on this case.
Okay.
I believe we made it this was back on April 9th was when this offer was made.
Judge, here is my response as best I can in my announcement. Mr. Denizard is on bond on this case, has been on bond on the case. We did file our entry of appearance back in January with motions. Subsequent to that, and I believe it's been about a month ago, he was arrested on a new set of charges. He does not have a bond on at least one of those charges. And so we have not had communication with Mr. Denizard. I learned last week that he was in custody when I had attempted to make an announcement. So we're not in a position to proceed on this case at this point.
Okay. What would be the reset? 1 week or 2 weeks?
What would Mr. Moran, like? Would you like next Thursday, Mr. Moran, or would you like the week after?
Judge, if we could, the week after, I am first out on a calendar before Judge Leftridge on a homicide case Monday. So that
Okay.
case, if called, is going to take the full week. So if we could do the following week, that would be helpful.
Okay,
Would you like the 28th or the 30th, Mr. Moran?
Give me 2 seconds to look at a calendar, if I may. The 30th would be preferable if we could.
Sure, so it'll be the 30th at 9 a.m. in this same Zoom link, and we'll make sure that you receive it this time.
Thank you so much. I really appreciate it. I thank the court for your
All right.
indulgence, Your Honor.
no worries. Thank you. Take care.
Okay.
All right.
Going 28, 29, Mr. Stevens.
All right. This is 26 CR 002150Y, Calvin Stevens, and 26 CR 002151Y, Calvin Stevens again. State.
Your Honor, we are waiting on an announcement for this case from defense.
Okay.
We're ready for a plea, Judge. The only request I have is on the second case, if the fine can be either waived or switched to community service. There's like $135 fine.
That's fine with us.
So is that 13 and a half hours or just 13
Judge,
to add it to the 30?
I would prefer, if I may, Judge, just to waive the fine altogether. He already has community service to do in both cases, and also he's got $900 restitution. So I'm asking just to waive the fine.
We'd be fine just getting rid of the fine. We would ask for 10 additional hours of community service.
That's fine.
All right.
Okay, so that's in the second case. We're waiving the $135 fine, and then it will be 40 hours of community service.
Yes.
Okay, and then in the first case, he has a $900 fine and 40 hours of community service.
Restitution, technically, Judge.
I'm sorry, that's restitution. Sorry about that. I see that. Okay. All right, go ahead, State.
Yes, Your Honor. For position 28, the theft by taking, we are recommending 12 months, served 90 days, credit for time served, balance probated, an anti-theft course, no further contact with Miss Brianna Strong, stay away from Techwood Drive, being that strip from from 10th Street to 17th Street, essentially where it intersects with the highway ramps and whatnot. And that's in Atlanta. $900 restitution to Brianna Strong and 40 hours community service. And for position 29, 12 months probation concurrent with the aforementioned position 28 case. 40 hours community service, stay away from Techwood Drive, again, that same strip from 10th to 17th Street in Atlanta. And we would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea. We would also like to sound for Miss Strong at this time.
All right, Ms. Strong. I don't think we have a Miss Strong on the Zoom. All right, and that's your understanding as well, Mr. Hadi?
Yes, Judge. We stipulate for purpose of the plea, Judge. And according to my calculations that I've told that to my client, he's got an additional 30 days or so.
All right. All right, so Mr. Stevens, do you understand that you wish to plead guilty in both cases? Is that correct?
Yes, ma'am.
All right, let's raise your right hand so I can swear you in first. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you put your hand down for me. And let me ask you a series of questions to make sure that you understand your pleas, okay? First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder your understanding at this time?
Oh, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you are prepared and agree to waive these rights today, correct?
Yes.
Has anyone promised you anything to plead guilty?
Anybody told you other than what I just told? Anybody forced you? That's what she's asking. No.
All right. And has anyone told you that you would receive a lesser sentence for pleading guilty?
No.
All right. And do you understand that if you're currently on probation, it could be affected by this guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
All right. And as to the charge of theft by taking, how do you plead?
Guilty.
And as to the charge of pedestrian in the roadway, how do you plead?
Guilty.
All right. I accept your guilty plea and you understand your terms and conditions, correct?
Yes.
Okay. All right. Thank you. You're free to, we will accept your plea.
Thank you, Judge. All right, let you receive.
And then 24, Mr. Santana.
Okay. This is 26 CR 002149L. Rigoberto Santana, charge of 1 count of theft by shoplifting. Is this going to be a plea or what's the announcement?
Yes, this can be a negotiated plea.
Okay.
Yes, Your Honor, as to the theft by shoplifting, the state's recommendation is 12 months served 30 days, credit for time served, balance probated, anti-theft course, stay away from Target. That location is 3660 Camp Creek Parkway in East Point, and 40 hours community service. We would ask that defense stipulate a factual basis, venue, and ID for purposes of the plea.
All right.
We so stipulate.
All right. Thank you. And Mr. Santana, I understand that you wish to plead guilty today. Is that correct? Can't hear you.
Yes.
All right. Raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right. Put your hand down for me. I'm going to ask you a series of questions to make sure that you understand your plea today. All right. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you are giving up and waiving the right to the presumption of innocence?
Yep.
And you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
You understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you are prepared and agree to waive these rights today, correct?
Yes.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation could be affected by this guilty plea today? And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
So as to the charge of theft by shoplifting, how do you plead?
Yes.
All right, thank you.
And Your Honor, we were going to ask also for a fee waiver and non-reporting status after completion of the terms.
That'll be fine.
All right. So he'll go non-reporting after, was it termination or non-reporting?
We're fine with non-reporting, Judge.
All right, non-reporting after he's completed the conditions, and I'll waive 1 month of the probation fees. All right.
Thank you, Your Honor.
All right, thank you.
Yeah, number 30, Ms. Taylor.
Okay.
Mr. Santana. That's 44.
Thank you.
All right, this is 26 CR 002169A. James Taylor, charge of 1 count of criminal trespass. What's the announcement?
Yes, Your Honor, we were going to ask for a bond hearing on this matter.
All right, is there a present bond?
I believe so.
$1,000 surety is what I see, Your Honor.
Okay.
Also pulling this up, Your Honor. He is going to ask for a signature bond today. He would really like to pursue trial on this matter, but is unable to meet the current bond. And I would like to request this bond hearing in order to enable him to meaningfully pursue his case at trial.
All right, state. Is pretrial back on yet?
Yes, Your Honor, I'm here.
All right. Do you have the history on position 30, James Taylor?
Yes, ma'am.
Okay.
There are, hold on, I'm sorry, multi-state interaction. 1 from California, 1 from Minnesota, 15 from Illinois, 1 Nevada, and 7 from Nebraska. There's an active warrant from Schuler, Nebraska for terroristic threat. Date of that warrant is June the 12th of 2024. Excuse me. There's a 2018 conviction from Illinois for aggravated unlawful weapon on person and armed habitual criminal. There are 8 convictions outside of the 10-year period. There's an open case from Olmsted County, Minnesota for obstruction of legal process and theft by taking, use, transfer, movable prop, no consent. And there's a 2011 FTA out of Nebraska. The recommended level, if placed on pretrial, is level 3.
All right.
Yes, Your Honor. As you heard, several violent convictions in the past. I believe, as pretrial stated, most of those were Illinois. Of his 15 cycles there, he spent a good amount of time imprisoned in Illinois on account of those charges. That he was sentenced to in total between the aggravated unlawful use of the weapon and the armed habitual criminal conviction. Another for the same and the prior aggravated vehicular hijacking, roughly 15 years is what I'm seeing there. And then subsequently, I saw there's a fugitive from justice arrest out of Nebraska from 2020. And as you heard, he's wanted out of Nebraska for terroristic threats and acts. So there is a substantial flight risk here, Judge, given the cases. This was an April 2nd incident. MLK Jr. Drive and Washington Street is the location. Officer observed 2 males running in the street at that location, and they were yelling at each other, taking an aggressive stance. Both of them gave commands for them to separate and leave the area. They failed to comply. One of those individuals was later identified as a defendant. And it was only subsequently that that one of the males left the immediate area. That was the basis for the original disorderly conduct charge, but we don't have the identity of the individual that had left. So we did NOD, the disorderly conduct in this case. But the officer the defendant remained in that immediate area. He returned, and that was to the property there, walking several feet, turning around and walking back after the officer told him to leave the property, gave more commands for him to leave the area. And he walked over elsewhere, and that was he walked across MLK Junior Drive, sat on the barricade there at the corner of MLK Junior Drive, Washington Street. Officers told him he was still on that state property there, and he needed to keep walking and leave. He refused those commands and stayed seated. The state's requesting that the bond remain as set, $1,000 surety, given the flight risk here, based on his history.
Okay. PD?
Yes, Your Honor, Mr. Taylor, though he's relatively new to the Atlanta area, he did come here to put the events that were just mentioned by the state behind him and to lead a new life. He has been committed to being a law-abiding citizen for many years, and I do not believe that he poses a significant risk of reoffending while awaiting trial. And I also believe that he is a low risk of flight because he has plans to apply for a Georgia ID and establish his residency here. He has close friends in the area that he plans to stay with upon release. And he is actively looking for work here in the Atlanta area and even aspires to start his own business here. That is why he came here in the first place. In addition, I don't think he has any risk of being, he will not be a threat or danger to people in the community itself or property. The other individual mentioned in this report was a complete stranger, and he maintains that that stranger brandished a knife at him and that he feared for his life, and that is what resulted in the standoff and the running that police witnessed. I don't think there's any risk of intimidating witnesses or obstructing the administration of justice because in addition to not having any interest in doing that, he doesn't even know who this other individual is. So it's a stranger. Mr. Taylor has faith that the court is interested in justice and that if given the opportunity to present his case at trial, justice can be achieved. His pretrial release on a signature bond would enable him to meaningfully assist his defense at counsel. And we hope that the bond will be granted.
What was the date of that last conviction? Was it 2018?
That's what I have, Your Honor.
And he hasn't had any convictions or arrests since 2018 or just?
No, he has. There was a 2020 fugitive from justice arrest in Nebraska, and then you did hear that he was wanted out of Nebraska for terroristic threats from 2024.
Okay. Well, I'm going to leave the bond at the 1,000 surety.
And we'll go to Mr. Nye.
We're still you're good.
I'm sorry, say that again.
He asked for a moment, Judge.
Oh, okay.
All right. Thank you. Your Honor, I think we are going to proceed with negotiating on this matter.
Okay. State, tell me what the terms are.
Yes, Your Honor. For the criminal trespass, state's recommending 12 months, served 30 days, credit for time served, balance probated, recommending an Op21 law decision-making course. Stay away from that location there, where MLK Junior Drive intersects with Washington Street, 30 hours community service. And we would ask that defense stipulate a factual basis, venue, and ID for purposes of the plea.
We just
right. PD?
Yes, we do stipulate.
All right. Mr. Taylor, I understand that you wish to plead guilty. Is that correct?
Yes, ma'am.
All right, raise your right hand so I can swear you in first. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes. Okay.
All right. And I'm going to ask you a series of questions to make sure you understand your plea. You can put your hand down. Are you presently under the influence of any unprescribed medication, drugs, or alcohol at this time that would hinder your understanding?
No, whatsoever.
Are you satisfied with the services and representation of your attorney?
Yes, I am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yeah, I understand.
And do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, I understand.
And you understand that by pleading guilty, you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
I understand.
And you are prepared and agree to waive these rights today, is that correct?
No.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, they haven't.
Has anyone promised you anything to plead guilty?
No, they haven't.
And do you understand that if you're currently on probation, your probation may be revoked or affected because of the guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
So as to the charge of criminal trespass, how do you plead?
Yes.
All right, I will accept your guilty plea. You understand the conditions, correct?
Yes, ma'am.
Okay.
And, Your Honor, if I may, I would like to ask to waive all fees on this matter and go to termination once these requirements are complete.
State.
That'd be, in that case, that'll be fine with the state on this particular case.
Okay, I cannot waive all of the fees, but I will agree that he can it will be terminated once he completes the conditions. I can waive the first 2 months.
Months? Thank you, Your Honor.
Okay.
Yeah, I believe that's all we have, hey, Judge.
Huh?
I believe that's it.
You good?
That's it?
No, that's it.
That sounds good. We'll see where's Mr. Bartels.
That's it.
Make me a part.
Yeah.
Thank you.
We done with this? No, maybe that's it. Hey.
Any word on positions 1 and 2, and that's Robert Allen, and then position 19, Michael Lee.
Mr. Haddad, do you don't know anything?
What on the bullshit?
No. Judge, let me double check here.
I have the announcement from defense being pleased for both of those.
1 and 2?
Yes, Judge.
For 1 and 2 and 19.
That's what I have as well, but I don't.
What do you have, Mr. White?
Position 1 and 2 is Mr. Allen. That one is mine. I spoke with him yesterday and he had agreed to a plea. He is on another case, no bond status. So, I mean, he will not be prejudiced by resetting him if we wanted to do that.
Okay.
Judge, Mr. Lee's, it's a time served sentence. We're trying to find out why he was not brought to court.
Okay.
Yeah, that's on 19. On Mr. Allen, he wasn't brought to court either.
He was on the pull sheet, but let's see where he got.
Okay.
Find out.
Well, his attorney is okay with resetting positions 1 and 2, but
Allen is fine, but Lee is the guy we need. Michael Lee.
Are we resetting 1 and 2 for next Thursday or after that, Mr. White?
Let's do it next Thursday if we can.
Okay.
Thank you.
And I apologize, I missed the announcement. The paperwork goes to.
It's Casey Strong.
Okay, thank you, Judge. Thank
In addition, Mr. Srocco, number 9,
Yeah.
I spoke with him. That is a
Okay, thank you. Mr. Davis?
correct.
They said number 19, right? Yeah, he put on the call sheet though. Yeah, we'll file him though.
Yes, 19.
Is that the only one?
I believe so. 37 and 38 were highlighted. I don't know about those two.
Yeah, we did 38, but 37,
37 what?
he bought it out.
Oh, okay.
Your Honor, I also have position number 4, 5, and 6. He posted bonds.
Yeah, he got released too.
Is position number 14 in the courtroom?
Position
I
4.
know it says conflict, but I just want to see if we need to reach out. It says that Judge Law appointed Mr. Murphy, but I just wanted to make sure before we reach out to Mr. Murphy to see if he's in.
Is that South Bend? They never came on. So.
No, he is not. I think it looks like South Annex. They never came on. Yeah.
So we'll just reset it.
Yeah. You did? Okay. Make sure.
Judge Murphy, did you want me to go through the calendar while we're waiting for them to locate Mr. Lee?
We can.
Okay.
I didn't know.
Position number 1 and 2 are reset for next Thursday's SAP calendar, April the 23rd. Position number 3 was a plea. Positions 4 through 6 was release. Position number 7, 8 were a plea. 9 waived arraignment. 10 is being reset for April the 30th SAP calendar. 11 is being reset for next Thursday's SAP calendar, the 23rd. 12 and 13 waived arraignment. 14 is being reset for April the 23rd SAP. 15 waived arraignment. 16 is being reset for April the 23rd. 17 waived arraignment. 18 is being reset for April the 23rd. 19 we're holding on. 20 was a waiver. 21 is being reset for April the 23rd. 22 is being reset for April the 30th. 23 waived arraignment. 24 and 25, as well as position number 26 was a plea. Position 27 was reset for April the 23rd. 28, 29, 30, and 31 were all pleas. 32 is being reset for April the 23rd, as well as position number 33, 34, and 35, all reset for April the 23rd. Excuse me. Positions 36 and 37 were released, and 38 was waived arraignment.
And can we be sure to I think I wrote this down on the recommendation sheet, but can we be sure to add the defendants, and this is Christopher Traylor, he's 32 through 35. He's an additional open case, 22 CR 008289G, when this is reset.
Ms. Strong, I did.
Thank you.
Yeah, hey, it's Bill. Yeah, it's, I can talk to, Ms. Jones and Ms.
Could someone from the PDs advise I know there was issues with Mr. Dill he was the DV bench warrant case from Tuesday. Was that reset to today or was that reset to next week?
He's on today's calendar.
He's for today, and just so you know, I spoke to him. He called me yesterday, and he's gonna physically go somewhere where there's access to computers so he can log on. So, and Mr. White, I can handle that if you're done. We can sign off.
I mean,
I've already
there's
talked-
also, is that Dennis Weldon? Is that one we're doing as well?
Yeah, that's on for today.
Okay.
Yeah, I have not talked to Weldon, so.
I mean, if he logs on, I can handle it. It's not a problem. Mr. Rocker, you know if especially on the guy that is sort of challenged with getting on, if it's his first, I mean, and we can.
I think it is, from what I can tell.
If we could just agree to set aside the warrant, and then since Mr. Haddad has his number, he could just let him know. Does that make sense, Joanne?
It does, because honestly, I don't even know if he's gonna figure out how to log on. He mentioned that Ms. Hicks, I don't know who that is. I'm assuming somebody from the clerk's office, but I don't know. But yeah, I mean, I would ask Mr. Straka if we can agree to set aside the bench warrant on him. His address, I confirmed the address. He did get notice, but when he told me he was really sick, and it says he's disabled. I believe him, but you know, I eyes on him. But he's also he's my age. That's pretty old.
Let's see. Failure to appear, plea and arraignment before Roth. That was March 24th, 2026.
Mr. Lee?
Will we need him to appear here to set this aside? I don't see any, I don't see prior failure to appears. And I don't see return to sender notice on file, and the address is confirmed to be good. Let's see.
Yeah. I mean, I don't, we can, if you agree, we can agree, and then Mr. Haddad can give him a call and let him know, since he has his number already. Or Mr. Haddad, you can give me the number and I can give him a call. So either way.
I can reach out to him.
Anything we'd need to sign here?
He doesn't have to sign anything. I'll just send the paperwork.
Well, if that's fine with you, Your Honor, that's fine with the state here.
Okay.
So I would the bond order, or
I got it. I can do it. I just need the case number because that one's not on today's.
I have it. 25 CR 002798A.
I got it from here, Mr. Dodd, and I can handle Mr. Weldon when he comes on. So
thank you.
Okay, great.
Thank you, Mr.
Okay. Is this Mr. Lee?
Yes.
All right, this is 26 CR 001941B, Michael Lee. State.
Yes, Your Honor. For Mr. Lee, on the count of, excuse me. Could I get the position number again one more time?
19.
Oh, thank you. Thank you. I was looking at the prior calendar with Mr. Dill. For this case, the state's recommendation for the charge of simple battery against a corrections or detentions officer is time served. Doesn't look like he's going anywhere anytime soon with his current charges. And it looks like he's been in jail at this point for 617 days, though not on this charge. I don't have the calculation for the time for this charge here, Judge, but we are recommending time served.
Okay. Is that your understanding, PD?
Yes.
All right. And so, Mr. Lee, yeah, I would understand that you wish to plead guilty or a time served plea.
Yes, Your Honor.
Okay, raise your right hand for me and I'll swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Ma'am.
All right, put your hand down for me. I'm going to ask you a series of questions. Make sure you understand your plea. Are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder your understanding at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
No.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
No.
And that you're giving up and waiving the right to remain silent and not testify against yourself?
Ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today, correct?
Ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
And has anyone promised you anything to plead guilty?
No, ma'am.
And you understand that if you're currently on probation, it might be affected by this guilty plea today?
I don't know.
No, if you were. If you're not, then,
Yes, ma'am.
but, okay. Do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And as to the charge of simple battery against corrections or detention officer, how do you plead?
Good.
All right, and it's a time served plea, so no conditions, and that's it. Okay, thank you.
Good luck.
All right, we're ready for Mr. Bartell. I just saw him walk by.
Your message for me, please, Judge. Check your chat.
Oh, let's see.
There are a couple of folks on the calendar, Your Honor, that I need to speak with. I have plea offers from Ms. Tucker. Mr. Schrocker, are you doing that calendar or is she?
I am not. It should be her. I can reach out to her. But she's probably, I'm assuming she would be on in 10 minutes.
Yeah, I'm not quite ready, Judge. There's a couple of people I have talked to and relay offers.
So I guess we're just waiting on Mr. Weldon.
Yeah.
I'll bring it back to you. Is that what you're hearing?
Yeah.
Good morning, Judge Mincy. This is Miss Mann, the court reporter. I'm going to step off and
Yes.
use the ladies' room real quick. Is that okay?
Okay, yes, that'll be fine. Thank you.
Hey, Miss Grace, Mr. Weldon's on, if we can get a breakout room.
Sure.
Oh, Miss Strong, thank you.
Am I on? Can anybody hear me?
Judge Mincy, we're ready with Mr. Weldon if you are. I don't see him.
All right, you ready?
Well, actually, I don't see that Mr. Weldon is out of the breakout room yet.
I don't think okay. I'll hold for a second.
Is there, Miss Grace, is there anything we can do to like?
I'm sorry, we missed it. We were discussing something else. What's wrong, Mr. White?
Mr. Weldon hasn't come out of the breakout room.
Oh, okay, okay.
There he is, Judge.
Should be on now.
Gotcha.
Okay. All right, this is the DV bench warrant calendar, and I have position 2, 24 CR 0073718, Dennis Weldon.
Yes, ma'am. How you doing? Good morning.
Good, let's see. And what do we have?
Yes, Your Honor, the most recent FTA, the one that we're here for, is from his failing to appear before Judge Roth on September 22nd, 2025. That was for plea and arraignment. There's no return to sender notice on file here. This is not his first FTA before Judge Roth on this case, and it's not his first FTA for plea and arraignment either. The previous one was for the same on March 13th, 2025. That bench warrant was set aside. He provided an updated address at that time. I believe it was a specification of the apartment at that location, which is the address they've had on file for him since March 31st, 2025. It's 707 Angier Avenue, Northeast, Apartment 20, Atlanta, 30308. And it appears he provided the same address on April 8th of this year, and having this case be set for today's calendar. Seems he has older FTAs as well in previous cases. I saw at least 5. So the state would object to lifting a bench warrant here. We would object to him being given a second chance on this case, Judge.
All right.
Your Honor, he's not receiving a notice for whatever reason. He didn't realize he'd missed court until his bonding company let him know. He is out on bond. He works 2 separate jobs. He wants to get the case behind him. He wants to appear in court. Our understanding is the victim doesn't want to prosecute the case at this point either. Not saying that that's neither here nor there, but with that being the case, he does want to come to court. He didn't receive notice. We don't believe that's his fault. Either it didn't come from the clerk's office or there was issues with the mail. That is the correct address. That's the address he gave me. He's in contact with his bonding company. So at this point, Judge, we would ask to set it aside. We'd ask the case manager if we know for a fact that it went out and with that address on it.
All right, Ms. Strong.
Yes, ma'am.
What do we have in the file? Or did we get any return mail on this? Anything?
Hold on one moment.
Okay.
Let's see.
Remember, Mr. Weldon, you're not muted, so we can hear you.
I ain't saying nothing. I'm just trying to get this resolved.
No, there was no return notice. No return notice, nothing.
And it would have gone out a couple of weeks ago.
So his initial court date was September of last year, and that's when he missed court. And then I guess I'm not sure how he found out, maybe from the bonding company, that he missed court. And then that's when he came in and reset for this court date here.
Okay. So let me ask this question too. So when the notice goes out to the defendant, does it also go to the bonding company, or do they just check online?
The bonding company has a way of checking periodically with cases with defendants that have used them.
Right, but the clerk doesn't mail anything to the bonding company.
Not that I know of, but they very well may. I'm not sure if they mail them. Different judges are different, so I'm not sure, Judge. Different
Go
judges
ahead, Mr. White.
This is what I mean.
Right, Mr. White, you were going to say?
Typically, a bonding company wouldn't get an attorney. If he had an attorney, they would get the notice as well. And that's how he found out, is from his bonding company, but it was well after the fact.
Right. And same address, same apartment number. And Ms. Strong, we do have the apartment number on there, correct?
The 20?
Yes, apartment number 20, correct.
Yes, I apologize. So it's 707 Angier Avenue, apartment 20, Atlanta 30308.
How is you spelling it? I don't know.
I'm sorry?
How are you spelling the street name?
Oh, it's spelled Angier in the system. And this is what was updated March the 31st of 2025.
No, I ain't received.
So did you not update it again when you came in to reset your court date, Mr. Weldon?
At first, I was having an issue, ma'am, if I can speak, about my address was not, the apartment number was not on the sent out letter from you guys. And that's when I went the first time a year ago and put the apartment number. So now what's going on between September and now, I do not know. I'm not receiving the letters. I get letters from everybody else with my same apartment on there. I don't know why I'm not receiving the letters. So I'm out working, out doing my job, and just like a week or so ago, the bonding company called me out the blue and saying that something about the bond is something I need to go down to the J150 and get the new date. That's what I did. I gave him the address, and that's where we at here today, trying to see what's the issue or what's going on. You know, this case is from over 3 years ago, so I've been, trying to handle this since then. I didn't even know charges were put out on me. I was just.
I'm sorry, Mr. White. I didn't mean to cut you off. The only thing that I can suggest, because it does show that when he updated in March of last year and this year that it's the same address. I'm not sure why, but I would just say that, I'm sorry, Mr. White, and I'm not trying to overstep, to just check every 30 days if you give him the number, and just check periodically so you can say that you're doing your part. But I'm not sure why it's not coming, because it does. What's in the system is the same thing that you've listed on the reset notices.
And I did to him to check the website and to call the clerk's office and to call his bonding company as well.
Right. Well, I am slightly sympathetic with the snail mail that we have in the system these days. He's getting other mail. I don't know why not this mail. And then eventually, surely from last year, we would have received a return mail from over a year ago. But I have heard of.
That was assuming it delivered to the right place, Judge. And
yeah,
there are issues with the post office over the last few years. So.
Right. Well, I usually don't like to give a second chance, but I don't like what I'm hearing if he's updating at the same address. Now, if he kept moving, like some of them do, I would have said, hey, you didn't come down early enough to change your address. I will give it one last chance on here and not revoke you because I'm thinking there could be an issue with the mail. So now it's going to be on you, Mr. Weldon.
I cannot, I cannot just know.
Weldon, Mr. Weldon.
Yeah, this is not that calendar. This is not, there's a process and you can talk to your attorney about the ultimate overall
So is
case.
Mr. I can't remember the name. Is he gonna stay in contact me and let me know the date or how?
Mr. Weldon, ultimately it's your responsibility. So you need to check the county state website. You need
May
to
I
call.
have some numbers to do that, please? Or how would I get
Okay.
numbers to do that?
Casey, give him the number to the office. We have some people that call once a month.
I kind of like call every 2 weeks, once a month, whatever I got to
Okay,
do.
that's fine.
It's 404
Okay.
613
Okay.
5085.
085. And now the 612 number that I was getting called from, that's I can't call and check through that.
Oh, no, ma'am. No, sir. That was one of the litigation managers. That's so you would need to call the number that I gave you. That's the
Okay,
customer
now
service
this
number.
61, sorry to cut you out, but this 613-5085 number, that is to whom?
State court customer service. You give them your
customer
name and your
service.
case number, and they'll let you know if you have an upcoming court date.
Okay, may I have the case number, please?
Okay. Case number is 24 CR 007371A.
I got 24CR 007318.
7371A.
Hold on, let me read it back to you again. 24CR 007318.
No, listen, it's the last four numbers are 7371A.
73718.
Yeah.
Okay.
And please be sure you're checking with your leasing
And
office, sir.
when I call
That may
this
be the
number,
hold up there.
when I
Hold
call
on a
this number,
second, Mr. Weldon.
Okay.
Assistant Solicitor Scirocco said you may want to check with your leasing office to see if they've been having anyone else reporting problems with the mail. It is interesting. The most important piece of mail that you need outside of the bills is not coming. So you need to check with the leasing office to make sure there are no issues with it as well. Sometimes I tell people to go down to their local post office and make a complaint that I'm not receiving all of my mail. And they can also kind of flag it or put a notice there. And you can tell them I'm not receiving court notices. I get the bills, but I'm not receiving court notices just to make sure there's not an issue.
You're correct. I would do that. I go to the local post office and see what's going on while I'm not receiving letters from the court office. But I will make sure to stay on this state court. That's the state court clerk office, and call that number and get them that case number, and they should tell me a court date.
Right. So I think you're right. Call every 2 weeks. Just put it in your phone and call every 2 weeks like clockwork until you get the next day. Okay.
Yes, ma'am.
All right. Anything else? I think that's probably it for now.
Thank you.
All right. Thank
Good luck.
you. You're free to go, Mr. Weldon.
Thank y'all. Y'all have a good day.
You're welcome.
Bye-bye.
And I believe that's my business before the court, Your Honor. May I be excused?
Yes, you may. Who's doing this Malcolm deal, the first one?
I've got it, Judge. We've
It's
already.
you.
Oh, this is okay. His case. Great. Never mind.
Oh.
In which case, I'm still here then.
Okay.
Well, he's not on. We've already agreed to set aside.
Oh, there's a consent. Is there a consent order or?
Yes.
Oh. Are you checking on that, Mr. Scirocco?
I don't know if I
Did
received
you have
anything,
something,
but
Ms. Strong?
No, we agreed over Zoom 20 minutes ago or so, and I'm going to submit the order to set aside the bench warrant.
And state's consenting.
Okay. Sounds good.
Thank you,
All right,
Judge.
that calendar, that one's done. Okay.
All right. Thank you all.
All right. Thank you. See you next time. All right, Ms. McLeod, what do you have?
The competency calendar, Your Honor.
Oh, I'm not used to you being on that one. Okay. They've got you everywhere.
Yes.
And hi, ASG Tucker, how are you?
Good. I'm here ready for the competency calendar.
Right. I think Mr. Bartell said he had someone he needed to go speak with. One last person, I think. And he would be right back.
All right. I'll be in recess till he gets here.
Okay. Sounds good. Me too.
He's back.
You talked him up. Very good.
I think Bill Cloud has a case.
Say that again.
Ms. McLeod, do you have a case on the 11 a.m. calendar?
You know, I thought they had put my case on, but I see it's not on.
Yeah, I didn't see one of your clients.
Which is perfect for me. I get to log off then. Yes.
All right.
But thank
See
you
you.
so much for Miss Prejean's contact information. We have been in touch and she's been
Good.
very helpful.
Great. All right. See you next time. Mhm.
Set the ready, man.
Yes, we're on. Right now.
Mr. Bartel, you ready at ACDC?
I think, is the court reporter available?
She's there.
Okay.
Miss Mann. She's
Yeah.
there. Yeah. She just has her camera off, but she is there.
Yeah, Ms. Jones, Your Honor, she will be a negotiated plea. That is number 4. And Wilson, who is number 13, has a request to make regarding bond. So I believe that's Ms. Jones. Is that you? Okay.
Do I have a different calendar? Because Wilson is 12 on my
It was
calendar.
revised. They sent out a revised calendar.
Okay. Okay.
The only person who was added was Ernest Graves, and he's going to need a competency evaluation. So
Okay.
you don't have to worry about
Is his first time on the calendar?
first time. Yes.
Okay.
And he clearly needs an evaluation. Given his charges, I think the state would want one too.
I'm sorry, did y'all still want the YouTube and stuff to go while we were doing the competency?
Usually do they stop the live streaming, but we record.
Right.
Okay.